All right, let's talk to legal practitioner Inibehe Effiong for more on this new development. Mr. Effiong, there seemed to be a rebuttal to this story as to whether or not she released this statement. But let's look at the legality or otherwise of having a seven core member appointed as minister. The provision of the Constitution talks about the requirements that anyone who would be a minister must have, satisfy the requirement of the election of a House of Representative member.
Yeah, that's correct. And for you to be eligible to contest for House of Representatives, the requirements are there. You have to be a citizen of Nigeria by birth. You have to belong to a political party and be sponsored by that party. You must also be above the age of, I think, 25 now, by the not too young to run bill. And then, those are the important requirements, including educational qualification, which is school certificate or its equivalent. Now, the issue here is that the minister, Hannatu Musawe, has admitted to being a serving member of the Corp. I went through the mandatory youth service. I'm sure it's the same thing for you and most Nigerians who have gone through tertiary institutions. And I know, and then that is also consistent with the NYSC Act. Look at Section 2. You are to serve for a continuous period of 12 months, 12 calendar months, which is a year, continuous. Now, having been enrolled in the scheme, which is supposed to subsist for a continuous period of 1 year, and I know that under the NYSC bylaws, you are not even allowed to engage in business while you are serving as a core member. You are supposed to be completely disengaged from any sort of employment or job. So I don't see it as a proper thing, right, to have someone that is serving as a core member also serve as a minister. And my problem with this is about the precedent that this is going to set. Because what is the message, that she's telling Nigerians? That we can have one set of laws for her and a different for other Nigerians. But more importantly, if you look at the fifth schedule to the Constitution, in terms of the Code of Conduct for Public Officers, to which she has subscribed to, that oath. Now, you cannot be involved in double remuneration when you are a public officer, particularly when you are a minister. In this case, you cannot earn income.
Let me just cut in very quickly to make less as we get some clarity on this developing story. Indeed, there are conflicting statements on NYSC status. While a statement released by the minister on Sunday quoted her saying she hasn't breached any Nigerian law, there's another statement that we have now from our office saying the minister is yet to comment on the matter. The statement says, quote, "I deeply value and appreciate the support, solidarity, and understanding of Nigerians in these times. For clarity, I wish to state I have not issued any statement on the current issue." And this one was signed by the Deputy Director, Press of the Federal Ministry of Information and National Orientation. Mr. Effiong, this was also an issue some 3 years ago when she was appointed by the previous administration for another ministry. One would have thought that what does this say about the screening that happened at the Senate if this issue wasn't raised? Is that the Senate saying, well, it doesn't matter after all, since some would say the Constitution is superior to the NYSC Act?
I don't necessarily see a conflict here between the Constitution and the NYSC Act, really. What I see here is lack of due diligence on the part of the Senate, because if it was not proper, years ago when the then President Buhari appointed her into the board and she was rejected on the ground that she could not produce a certificate. As you have rightly noted, this matter has been going on for years. And I am surprised that Hannatu did not take steps, the minister did not take steps to have this matter resolved. So, is she earning her monthly allowances from the federal government by virtue of being a core member? If the answer is yes, that itself is a contravention of the Code of Conduct. Because you cannot be earning allowances as a core member and be earning salary and allowances as a minister. That is the point. That is not just a violation of the NYSC Act. that will be a violation of the Constitution itself. But the argument that she has met the qualification to be a member of the House of Reps and accordingly is eligible to be appointed as a minister, which is the yardstick, I appreciate that argument. But you must look at that argument in the light of the fact that even the NYSC Act itself, is part of the Constitution. It is one of the laws listed in the Constitution. One of the laws that can only be amended in the manner that the Constitution is amended. So I don't see it as the proper thing. I don't see it as the proper thing to have someone that is serving as a Corp member, serving as a minister. So where is that place of primary assignment now? Is it now the Ministry of Youth Act that is now a place of primary assignment? Or will she still be reporting at a PPA, be going for monthly clearance as a Corp member? What are we saying? So this doesn't speak well of the scheme. And it doesn't matter that she has not commented, even though she's now claiming she has not commented, because it is not in doubt that she's a serving Corp member. So I feel that this could have been avoided. This could have been resolved since she had decided to go back and re-enroll.
I hear you, Mr. Effiong.
Contrary to her earlier position.
But let me ask a more direct question.
Because she had earlier said,
if you can hear me, let me ask you a more direct question. As we speak right now, she hasn't broken any law, has she?
No, she has, because she is serving in the NYSC and also serving as a minister. One has to give way to the other. One has to give way to
Which
the
of the
other.
laws are you referring to now? Is there any section of the Constitution she has contravened?
Yes, I have cited, the fifth schedule to the Constitution that you cannot earn double remuneration while you are a public officer. For me, that is the strongest argument. But regarding the qualification to be elected into the House of Reps, yes, she has made those qualifications. But because she has, having been appointed, she has now put herself in a position where she is now contravening the Code of Conduct, which is also in the Constitution. I feel that the proper thing to be done is for one to give way to the other. That is the way I see it. It is not a problem without a solution. She knows what to do. She knows what to do, right? Let her either withdraw from the scheme, pending when she concludes her ministerial appointment, or let her take, a break from appointment as a minister and complete her scheme.
It's obvious which is more convenient to withdraw from. But that's our time. Legal practitioner Inibehe Effiong, thank you for sharing your thoughts with us on the news this hour.